everybody. So it is the 13th of October 2022. I'm Tara Lucke, and today we are talking about the Re Owies decision. So this is a part two installment of a case study looking at this Victorian case. And the reason I'm giving it 2 Facebook Live sessions in a row is that I think it's a really important decision that we all need to be aware of. I sent out my newsletter earlier this month, and I was like, this is the case law, the trust law case that changes everything and no one is talking about. So I want to focus on it again just to make sure that it's on your radar, because I do think it is really substantial. Thank you to everybody who is joining me. I'm just going to check my phone to make sure the stream is coming through. So just give me 1 minute. Okay, I can see that. Beautiful. There's no guest today. It's just me, Tara Lucke, if you don't already know who I am. There's a comments section, so you can chime in on the chat. Obviously, the more interactive, the better. It makes it so much more fun for me instead of just talking to myself. So what I'm going to do is start sharing my slides. So you should be able to see those. Before we kick off doing our deep dive into the decision, I just wanted to acknowledge that today I'm hosting this training from the lands, actually not the Tarabulung Bunda people. I'm on the Gold Coast today, so the Bundjalung people. And I also want to acknowledge the traditional custodians of the lands on which each of you are all living and learning and working from today. So this decision, I think it has a lot of lessons for anyone involved in discretionary trusts or family trusts. So the first part of the training that we did was last month, and that was all around the elements of the decision relating to the exercise of a trustee's discretion in a discretionary family trust. So I had special guest Tim Donlan of Donlan Lawyers come in, and we analysed that case in respect of what did it say about a trustee picking and choosing which of the beneficiaries could receive income or capital. And I have to say, the reason, I'm going to sound like a broken record, but the reason why I keep going on about this case is that the outcome was really not what I would have predicted or expected. And I think a lot of us are going to have to update our notion of how trustee discretion works. So if you have not seen part 1, I would really encourage you to go and watch that. What I've got here is to just show you where you can find it in the group. So if you go to the Art of Estate Planning main homepage, if you look under the featured section, I've pinned it to the group there. So you can just click on this video and it will come up for you. By the way, if you are ever looking for any training on anything, we have them all saved under this guides tab here. And gosh, there's like 4 years worth of videos there. There's 50 videos or something. They're all sectioned under headings that are really helpful. So if you haven't checked that out, go and check it out, because it's a really great resource. But if you want to go back and you haven't watched part 1, go and do that here. It's not going to be vital for today's session, so you can watch them out of order and watch this one and then go back and watch part 1. But I think they're really important for you to both watch. So let's get stuck into the decision. I went through a really detailed fact overview in part 1, so I will just keep it high level for this session. But basically, we're looking at 2 decisions from Victoria. In 2020, there was the Victorian Supreme Court decision, and then only recently, I think might have been August, we had the Court of Appeal decision. So I'll try and look at both of them. The Court of Appeal decision really focused more on the exercise of discretion issues, which we talked about last month. So the family that we're dealing with here is John and Eva. So by the time this decision came to court, they had passed away. They were really elderly in their 80s when all of this was sort of happening. They had 3 children, and essentially what was happening is they were favoring one of the children over the other 2. So this is not an uncommon situation. And when you think about it, it's a really vanilla family trust succession exercise that would probably come across a lot of your desks, which is why I'm giving this case so much airtime. So we've got a family trust. It's just a standard discretionary trust. The deed is from the 70s, so it's a little bit old. Fairly decent estate in there, about $23 million of net assets, generating a really significant annual income of hundreds and thousands of dollars. They had a corporate trustee. That corporate trustee was pretty much there across the life of the trust. And then we had a role of guardian and appointer. So first we had John, the patriarch, and then Eva was initially nominated. They had the standard kind of general beneficiaries, including the extended family, but the range of primary beneficiaries was John, Eva, and their 3 adult children. So there's issues here about deeds of variation, changes to the directors of the corporate trustee, JJE nominees, and that's what I'm going to focus on today. Basically, when we go back to that family tree, Michael was the favored child, and John and Eva had various levels of estrangement with Paul and Deborah, and Michael was also somewhat estranged with them as well. Deborah's scenario is that she just had ongoing chronic health issues essentially from the time she was a young adult at university, never really earned very much, lived in an apartment owned by the trust and just sort of got by, but just chronic health issues the whole time. Paul went off, was involved in, had a finance degree, ran his own business. He also, over time, became estranged from his parents and his brother, though. I won't go into this income distributions, but because we talk about it a lot in the part 1 training, but effectively, throughout the life of the trust, they had this default pattern where 40% of the income was distributed to John, 40% to Michael, and 20% to Eva. And Eva really, she only got that lesser amount because she had other income. So they're just trying to sort of manage everyone's tax rates, basically. So as you can see here, Paul and Deborah really were missing out. I'm just looking at the questions as well. So thank you, Camille, for your question. And I mean, in terms of your question about will this type of claim become more likely as an alternative to family provision claims? Yes, absolutely. There were parallel family provision application claims on foot, as I understand it, but this is definitely something we're seeing a rise in. People, when there's family trusts, disgruntled family members are starting to attack the exercise of trustee discretion and just whether the affairs of the trust have been managed in order as an alternate way to receive a remedy that they may not have. So this is why I want this to be on everybody's radar, because as practitioners, whether you're an accountant, financial advisor, or a lawyer, I really do think you need to have all of your ducks in a row and be across this. We've also seen cases where these types of challenges have been brought by people who are in the family group, in the discretionary range of beneficiary classes, but themselves are not eligible to bring a family provision application. You know, stepchildren, grandchildren. I know the eligibility changes depending on what state you're in, but this is something that people can have up their sleeve as a way to seek a remedy when they couldn't otherwise bring a family provision application. So it's really just worth having this on your radar. So we're not going to go into real and genuine consideration in much detail, but the three main takeaways from that aspect of the decision, to summarize part one, is if you have clients who have family trusts, I really would encourage that you and your whole team get this case on your radar, have it in the back of your mind. If you're an accountant, I really think that you need to review and update your end of financial year distribution resolution template before we get to the next end of financial year. So Tim and I talk a lot about that, what that involves and what your template needs to do potentially to avoid being attacked for a lack of real and genuine consideration on the part of the trustee's exercise of discretion. And if you're not an accountant preparing those distribution resolutions, you're a lawyer or a financial advisor, this is still really important. You have to update your understanding of family trust and succession planning. So as I mentioned, and thank you to Camille for mentioning this too, challenging trustee discretion, appointer, guardian, trustee succession, this is a really hot topic in trust law land, and we're seeing a boon of litigation in this area. I've got other cases that I'll talk about today, where this is kind of, this Re Owies isn't necessarily particularly new news. We are seeing other cases with these themes as well. I just think Re Owies does a really good job at wrapping it all up together. Okay, so I'm just going to move the banner off so you see every part of the slide. So hopefully that looks good. And thank you everyone for the questions. So keep them coming if you like. So what are we going to talk about for this section? We're going to talk about what happened with deeds of variation, succession of the appointer and guardian, and also change of directorship for the corporate trustee. So we started out, John, our family patriarch, he was the initial appointer and guardian, and the deed said after his death and his wife Eva. Now, in 2002, they tried to amend that so that Eva became a joint appointer and guardian with John, and then after the death of them, Paul and Michael. So we can see there, Deborah has been estranged at that point, but Paul was still in favour. In 2010, another deed of variation was prepared. They made John the sole appointer and guardian, and then Eva was to succeed him, and then after her death or incapacity, Michael. And then in 2017, John's health was failing, so they sought to, and I think Eva had lost capacity by that point, so they looked to remove John as the appointer and guardian and put Michael in his place, and then after his death, Michael's legal personal representative. There's also issues around the succession of JJE nominees, which was the corporate trustee. So for a long time, John and Eva were just the joint shareholders and directors, as you would expect. Eva's health started to fail in 2017. She moved into aged care, had lost capacity, and she ultimately died in 2018. In 2019, John's health was declining. He transferred his share in the company to Michael, and they tried to put Michael in as a director. In 2017, so to replace Eva as she was starting to lose capacity, their long-standing solicitor, Mr. Sampson, was purported to be appointed as a director. There were issues relating to whether that was valid or not, and so in March 2020, they sought to rectify that and appoint Mr. Sampson as a director with Michael, and then John died in 2020. So we've just got this like transmission of control of the directorship of the corporate trustee as well, but we had the same constant corporate trustee the whole way through. So what did they do wrong coming at this with the benefit of hindsight? What were the issues that Paul and Deborah sought to challenge. So just as a refresher, when you're reading the case, you'll see, they just had a big shopping list of things that they were unhappy about. A big element of that was in the exercise of each annual income distribution, that they said the trustee did not execute its duty to give real and genuine consideration to all of the beneficiaries. That's what we talk about in part 1. I'm going to look at the other issues which we didn't talk about when we were doing part 1. And the big one here is that the variations, those 3 variations throughout the sort of 2000s, were outside the scope of the variation power in the deed. So they said, well, actually, you've tried to change the actual current guardian and appointors and the succession plan for those roles through a deed of variation, but you did not have power under the trust deed to make those purported variations. So Paul and Deborah were saying that they were void, and basically all of those changes were ineffective. There were also other issues which I'll talk to you about: board of directors, minutes of meetings, consents, which we'll look at in a moment. But let's just look at this issue around, what's the purported variation within the scope of the variation power? So the critical thing here is that it is the schedule of the trust deed which nominated the appointor and guardian. So it wasn't set out like in the defined terms or within the body of the trust deed itself. It was in the schedule. And so that's not uncommon, right? So to start, our starting point, it was John and then Eva, both for guardian and appointor. So I'll probably just refer to the appointor role because they mirrored everything for the guardian role, and there's really not a lot of distinction between them. The variation power was in clause 20, and I've tried to mark here in pink. So I guess if you're looking at this on your phone, you might need to turn it around so it's big enough to read, but because I've set out here the variation power. So it's a standard variation power, but for what I've got here in pink. So the trustee can vary the deeds with the consent of the guardian if they're alive. They can revoke, add to, or vary all or any of the trusts hereinbefore limited, or any trust limited by any variation or alteration or addition made from time to time, and may, by the same or any other deed, declare any new or other trusts or powers concerning the trust fund, blah, 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 can't infringe the law against perpetuities or be in favour of the settler or affect an existing beneficial entitlement. So this section down here is pretty standard. What I want you to focus on is the fact that they're saying you can only revoke, add to, or vary all or any of the trusts hereinbefore limited. Or you can only declare any new or other trusts or powers. So the difference here is the first part about revoking only refers to trusts hereinbefore limited, before clause 20. And declaring new trusts or powers, so you can only declare new powers. So if we're looking at this and going, well, okay, we can change the trusts, but we can't change the powers. We can only declare new powers. Have we got a narrow variation power here, or do we have flexibility? So that's the context of our variation power. Now, I've got here what they did in each variation, deed of variation, but basically all of them tried to do this. They relied on clause 20 to alter the description of the guardian appointor in the schedule. So they each tried to basically go, all right, our original deed says in the schedule, guardian is this, appointer is this. We're going to throw that out and replace that section in the schedule with our new definition. So 2002 did that. 2010 did that. Again, tried to amend the guardian and appointer definition. And then in 2017, again, they tried to amend the schedule to change the guardian and appointer. So the question that came up in the initial Supreme Court decision was, can you vary the schedule within the scope of the Clause 20 variation power? And it all came down to, what does it mean about the words trusts hereinbefore limited? Does that include the schedule? And they relied on the Jenkins and Ellett case and the McCanty and McCanty case. So I'm a Queensland-based lawyer. Jenkins and Ellett is a 2008 decision from Queensland, and that decision is seared into my brain because I think I must have been like newly admitted 1 or 2 years in, and I remember having like lengthy boardroom trainings on this case because this was a Queensland Supreme Court case about a very similar variation power that we have here. And so for me, I look at this Re Owies and I go, clearly that's a problem. But I think I have the benefit of being a Queensland lawyer. And this is just Jenkins and Ellett was like a Queensland Supreme Court case that I don't know if it got the airtime nationally that it did get with Queensland practitioners. But McCanty and McCanty is I think it's a 2015 decision. And it has a really similar variation power. And I have seen throughout the course of my practice tons of deeds that have almost identical wording to what we've got here in Re Owies. But I do think that this generally is a sleeping issue that unless you've sort of happened to come across a case where it's been a problem, you may not be aware of it. So I really, really today want to emphasize why this is a problem and the rationale behind it, so that hopefully, I'm searing this into your brain now if this isn't something that's on your radar, because we're just seeing lots and lots of cases now coming before the courts where this is a critical issue and it undermines an entire succession plan for a discretionary trust. So we're going to have a little trust law lesson about what does trusts in a trust deed mean, what does powers in a trust deed mean. So I'll spoil the ending in terms of Re Owies. The court said, given the trust deed makes this clear distinction between the trusts and the powers and provisions in clause 20, and they also went back and looked at other clauses and particularly clause 2, then clause 20 must be taken to support the conclusion that the variation power does not extend to the powers of the trustee. It only extends to the trusts of the trustee. So basically they're saying there is no duty or obligation of the trustee to amend the definitions of appointer and guardian in the schedule, and so it is not a trust. So they really dive down into the difference between a trust power and a mere power. So what we might do is take a little detour away from Re Owies and look at this Jenkins and Ellett case from 2007. Okay, so again, another family succession plan gone wrong where they tried to change the principal. So in this case, it's the principal, but I believe they had the similar powers to the appointer that the appointer had in Re Owies. So we had trustees of the trust, George and Luciano. Principal was George. So George is the principal. He can unilaterally change the trustee of the trust. He purported to remove Luciano as trustee and replace them with Joyce, who was his daughter. So now it was going to be George and Joyce. And then George and Joyce as trustees purported to remove George as the principal and appoint Joyce as the principal. And importantly, they did this by varying the schedule. Instead of relying on like the power to retire the principal and appoint a replacement, they just said, oh no, we won't bother doing that. We'll vary the schedule instead. So very similar, sorry, I'll just clarify, very similar deed layout in the sense that it is the schedule which said who the principal was. So the variation power in that case, really similar. The trustee may by deed revoke, add to, release or vary all or any of the trusts declared, and may declare any new or other trusts or powers concerning the trust fund, but you can't give the settlor a beneficial interest or affect any beneficial entitlement of a beneficiary, etc. So again, similar concept. The varying relates only to the trusts. The powers can only be added or declared new powers. Okay. They said that when you interpret the deed, the power to amend in clause 11 does not extend to the schedule because of the use of the words the trust declared. So I keep going on about the trusts and the powers. So let's look at what is a trust power and what is a mere power. So this case from the 70s, Lutheran Church of Australia, which I've got down the bottom here, says the main difference is that for a power or a mere power, the trustees have no duty to exercise it. It's optional. So we all know as trustees have a fiduciary duty. We have to have a express power in the deed if they want to do something with respect to the trust property. So that's why we see these trust deeds with like pages and pages of the trustee can do these things, these powers if they want. So anything where it's optional, it's in there if the trustee elects to do the thing, but they don't have to do it, is a power or a mere power. A trust power or a trusts, when we see it in the context of the variation power, is something that the trustees must exercise. And if they are in default, the court will do it on their behalf. So it is a matter of constructing the deed, whether something is a mere power or a trust power. When you look at a deed, there are very few trust powers. An example off the top of my head, for instance, is the default entitlement to income at the end of the financial year or to capital at the end of the trust when it's vesting, where it says, this is where it must go. That's something that if the trustee doesn't do it and they're required to, then it will still happen. The court will make it happen if it has to. But like 95% of the terms of a discretionary trust deed are mere powers. They're just things that the trustee might choose to do at their discretion. So understanding this distinction is what really goes to the core of these decisions and how they're interpreting the variation power. So if you can think of this like this, when it says the trusts or the trust power, the trustee must do it. They're under a duty. Mere power, it's just discretionary. So if we go back to the Jenkins and Ellett variation power, you can see here, revoke, add to, or release or vary all of the trusts declared, something that the trustee has an obligation to do. They can declare new or other trusts or powers. So they can declare new trust powers where the trustee has an obligation, or new discretionary powers. But you cannot revoke something that or vary something that is just a discretionary power. So looking, they had a whole look at the full language of the deed in the Jenkins and Ellett trust deed, and they're basically saying in the variation power, the words trusts in the first section means you have to interpret that not as a trust, as a mere power, but as a trust power. So they even go to the difference between where it's used singularly, where it's used in the plural. If they wanted to draft it this way, they would have done it another way. So they go through and they look at it all. They also basically look at, well, does it extend to the schedule? And they say the trust constituted by and comprised in this deed and the schedule. So that they're saying the schedule is not part of the trust deed, and the variation power it doesn't say here that you can vary the schedule. So they're saying, well, because the initial section of the trust deed in clause 1 is separating the deed and the schedule, then only the variation power relates to the deed. There were also issues around when they used the trustee's variation power to change the principal without the principal consenting, that actually destroyed the substratum of the trust. The whole purpose of that principle is to serve as a check and balance on the trustee's powers. So you can't have the trustee just unilaterally changing the principle, because that undermines that check and balance role. So even though I'm pretty sure the trustees were George and Joyce, and George and Joyce together removed George as the principal, that wasn't enough. He needed an express consent to be removed. So, this case is really frustrating, because I'm pretty sure when you look at the deed, there was an effective power for the principal to resign and appoint a replacement. So if they had just done that instead of burying the deed, it would have not been an issue, assuming they had done that validly. But they tried to vary the schedule. They didn't have power to vary the schedule. They only had a very narrow variation power, which didn't involve or didn't allow them to change the appointer through a variation. And then they also didn't get consent. So there were 3 reasons that this whole thing didn't work. If we can go back on track to looking at our Re Owies. So again, if you look at this variation power, you can only vary the trust herein before limited. I would almost be concerned about varying anything after clause 20, even as a trust, if it was a trust power. And they're saying you can't vary the trust powers. The mere powers. You can't vary a mere power. You can only declare a new mere power. So very similar language to the issue in Jenkins and Ellett. So we have an issue about twofold. whether we can vary the schedule. And even if we could vary the schedule, the definition of the appointer and the guardian is not a trust power, it's a mere power. So again, they followed that and they said a power to vary a trust is different to a power to declare a new trust or a new power. So they really did follow what was held in Jenkins and Ellett to say you just didn't have the variation power to do that. I'm just going to have a check on the questions. So yeah, do you think the settler intended to do all of this? It seems so restrictive and not keeping with the current client intentions. Look, honestly, no, I don't think so. A funny thing seems to happen with trust deeds where there's like trends that we see in the marketplace where someone drafts something and then other providers pick it up, and you see them like through all different deeds from different providers, or back in the day, like the accountants, the accounting firms, and they still do it, they all use like a white labeled trust provider. So if there's an error there, it kind of can get spread really far and wide. So in the 1970s, I'm just like talking off my head here. I really don't know. I wasn't even alive back then. But my sort of guess is in the 1970s, firstly, trusts were not as commonplace, and they definitely, those older deeds definitely did not afford anywhere near as much flexibility and freedom as what we like to see nowadays. And I also don't think that people contemplated that trusts would go for the full 80 years that they are allowed to. There's a lot of deeds from the 70s and the early 80s where they didn't even allow for the 80-year vesting date. They just picked 30 years or 50 years, and they just, I don't think, had that like foresight to build in the longevity that we try to do now. And I just don't think people contemplated that trust deeds would be anywhere near as popular or as used so commonly. So I think there's that maybe they did try to be really restrictive and rule from the grave a little bit, but it also could just be that the drafter was not as experienced in really understanding the difference, and the users, the clerks and the accountants and the people, rolling these out didn't realize either. I don't know. I'd really love to hear from people who do have a better insight on that. But it's frustrating because now in 2022, we can only do what is permitted by the deed. So in some respects, our hands are tied. When I have been updating a deed with a power as restrictive as this, what I will do is just make sure that I only add in new discretionary powers. So you're really actually not varying a lot, or if anything, because if it's a trust power as opposed to a mere power, chances are that there might be stamp duty consequences if you're trying to change something in the deed. We used to be really worried about the CGT resettlement, which of course is not as much of an issue now following Clark, but you do need to probably be very cautious if you are going to vary something that is a trust power. So what I would do practically is just add in new words or new powers, and even maybe to sort of say, if you're really stuck, to say, on and from this date, this power overrides the old power or something. You have to sort of be mindful about how you're doing it so that you're not inadvertently revoking it, even if you're not expressly revoking it or burying it. But it's not like you can't do anything, but you do have to be really careful. Another thing that I am really careful about is doing anything to vary a schedule. This comes up in our TT Precedents Club a lot, going, oh, can we just like put the testamentary trust terms in a schedule to the will? And I think that would be really client friendly, but I've been very resistant to do it because I'm worried that it might create problems down the line for managing the trust. I think an easy way to sort of overcome that is by making sure that when you draft your variation power, when you've obviously got a brand new unexecuted trust deed or testamentary trust will, is to absolutely be, in your variation power, be really clear. They can say, and they can vary the schedule. And that could probably override it. But I just get very nervous because we see a whole string of cases where people vary schedules and they're held to be invalid. So I think, if you are doing any kind of deed of variation, have that on your checklist, that you are not varying the schedule, or if you are, that you are really confident that you have the ability to do it. So I guess that's what I want to say about the variation power. I know that's taken half an hour or so, but I think it's really important, and I'm really just hoping that if anything, this just next time you're looking at a trust deed and doing a deed of variation or a succession of an appointer or principal, that you just take a beat and just have this flash up in your mind. Oh, I'm just having a look at your comments here. So I think I can put it on the screen. Some of these older trustees really have the most extraordinary provisions. I have one now that allows the appointer to appoint a new trustee in the place of a trustee who resigns or is removed, provided that as long as the appointer is a beneficiary, he shall not be eligible to be appointed as a trustee. Yeah, really, really interesting. And I can say maybe they wanted to do that because when they initially planned out the deed, the appointer was going to be an independent or impartial person, and they didn't want, an abuse of power or something. But long term, where the deed is closely held, I can see that's a huge issue. And you have to be really careful that you read the entirety of the deed when you are changing things, because if you didn't notice this clause and you did decide to put them in as the trustee, it'd be entirely invalid. And then where does that leave you with respect to the trust, every action by the trustee, including the annual income distributions? Are they all ineffective? So and look, someone said just set up a company. Yeah, these things, there's always a solution. There's always an easy way to get around it. But I think the message for us practitioners is that we can't make any assumptions when it comes to reviewing the deed, because they are all different. They can all have quirky clauses in there. And unfortunately, that issue about limiting who can be a trustee, it may not even be within the section relating to change of trustee and appointer. It could be in a totally different section. So you really have to read these deeds inside out, back to front, so that you know what you're dealing with and you can come up with a solution. Because as I was saying, in the Jenkins and Ellett, I don't know why they didn't just do a deed of retirement and appointer of principal. That would have solved nearly all of their issues. And in fact, doing that type of deed is sometimes a lot easier than a deed of variation, in my opinion. So if it's more about, there's different ways that you can cut up the orange or approach a problem. It's just knowing what you've got, really understanding the deed and the language of it, and then making sure you go down the appropriate path. And don't I suggest that they should have given themselves the power to vary the schedule? Well, I think if you've got a brand new deed that is unexecuted, right? Your client is coming to you and they're saying, I want a new family trust deed. And you've got a deed, you're drafting the deed, or you're a provider of trust deeds, and you do like to use the schedule to set out all the provisions, then yeah, make sure your variation power allows you to vary the schedule. But for a deed that is already established, there's an argument that you can't use the variation power to vary the variation power to allow it to vary the schedule. Does that make sense? Like, you're stuck with the variation power that you have in an existing deed. So if your deed does not allow you to vary the schedule, that's a dead end. You can't do it. You know what I mean? I would be I think there's a debate about whether you can vary the variation power, relying on your variation power. I'd be very reluctant to do that if I had other options, for sure. And then I would want to have done like a position paper confirming I can and it's cool before I went down that path, if that makes sense. So clean skin, unexecuted documents that are not in place, yeah, make sure you can vary the variation power. Vary the schedule with the variation power. But, with a deed like this, Re Owies one is from the 1970s. We can only really work with what we've got. So I hope that makes sense. But it's a great question. And you can see how these things get a little bit complex quickly. So if we just get back on track, away from our detour about mere powers and trust powers, to the other problems that arose in the Re Owies case. So there was two other main mistakes or issues. They're probably more issues than mistakes per se, but I would think that these are mistakes that we could make that, again, can be so easily avoided. So because we've got a corporate trustee, Paul and Deborah said, your directors did not validly resolve on behalf of the company to enter into these deeds of variation anyway. So there was no documented director resolutions or minutes of meeting of the trustee authorizing the execution by the corporate trustee to enter into the 2002 and 2010 deeds of variation. Now, those deeds were signed by John and Eva as the director and secretary, and they put their corporate seal on the deed. So, but Paul and Deborah are saying, well, you did that, but did you actually have the necessary meeting of the directors to actually resolve to take this action, to enter into it? So Paul and Deborah did not win on this argument. It was saved by the presumption of regularity. Look, I'm definitely not a corporation lawyer, but my sort of reading of this, of the argument and the judgment, was that the onus was on Paul and Deborah to prove that the meeting didn't happen, as opposed to the company having to prove the meeting did happen, if that makes sense. So Paul and Deborah could not put forward enough evidence to say that it didn't happen. So they were saved by this. But it was an issue, another issue that came up that everyone had to deal with, and they could have lost. There was also an issue around what happened in 2017 and even who the directors were. So Eva was losing capacity, and there was actually a VCAT challenge. I don't really know the details of that issue, but there was a question about whether Eva even had capacity. So her son, Michael, was her attorney. Their lawyer, Mr. Sampson, was put in as a third director just to make sure, in case Eva wasn't validly a director, I think. So the appointment of Mr. Sampson as that third director was signed by John, and then Michael signed it as Eva's attorney. And then the next day, so that was done to sort of fix up the directors, and then the next day they signed the 2017 deed of variation, and then Mr. Sampson, the lawyer, who had been appointed as a director the next day, and John signed the deed of variation. So Paul and Deborah again challenged that there was no directors meeting to do that 2017. There was no evidence of a minute of meeting at all. So the court said, despite the absence of a minute recording that they had made that resolution authorizing the trustee to execute the 2017 variation, there was a demonstrable expression of the common will of John, Eva, and Mr. Sampson to approve the variation. So even though they might have met very briefly the next day to sign the deed of variation, they did. So then they were saying, well, only 2 of the 3 directors signed the variation. So did they really have a quorum of directors at the meeting to agree to enter into it? Because, yeah, I think Eva was there when they appointed Mr. Sampson, but the next day when the deed of variation signed, I don't think Eva or Michael was there. But Eva, even though it was concerned about her capacity, there seemed to be enough evidence that she was still doing things. Like, she was the one who initiated the deed of variation and like called up Mr. Sampson and asked for it, or whatever she did. So they basically said there was a meeting of minds and there's enough to get them there. So they also, even though there wasn't officially a quorum, it was okay because the memorandum and articles of association had a saving provision which validates defective acts. But on the other part of that, Michael, who was meant to vote as Eva's attorney, had not, his power of attorney had not been registered with the corporate trustee or something. So there was all these kind of things that they just did a little bit sloppily. The court was pretty liberal in this and said, look, we can kind of tell they all got together and made this decision, so it's okay. But my point here is that, you know, a resolution of directors or a minute of a meeting, it's like a one-pager. You know, you basically just say, the trustee was presented with the deed of variation. The directors considered it and resolved to enter into the resolution. Resolved to sign the deed of variation. And you have one page that goes on the file, and it just eliminates all of these issues. And Paul and Deborah would just have not even been able to challenge it or even have the issue or the question. And this, when you read the judgment, it really comes down to the facts. So they had enough factual evidence, and I think, you know, it was probably pretty lucky that Mr. Sampson was a lawyer and he'd had file notes and all of that to sort of prove that they had had these conversations, but it probably could have turned the other way as well. So even though you might be looking at these like precedent packs or whatever you've got going, oh, is this one-page of resolution really that important? Like, it actually is. It can really save you bacon. So I would just make sure that you really do cross your T's and dot your I's, and you make sure all the directors are there and the resolutions are documented and you follow the Constitution in terms of the process. The third issue was guardian consent. So we saw this in Jenkins and Ellett as well. the variation power required the guardian to consent. So there was issues about was Eva even a joint guardian or not, and where for 2017 where the lawyer signed, Eva didn't sign anymore. So is that a problem? Did she not consent? And then in one place, she needed to consent and she only signed as secretary of the corporate trustee. So that was another thing that Paul and Deborah challenged. And in this decision, Re Owies, where are we? They said it was okay. Her consent can be inferred by the circumstantial evidence. Incidentally, I've just put this quote here because there's always this issue about whether the guardian power is fiduciary or not. And as a side, they said in this case, it becomes down to a construction of the particular trustee and the powers conferred on them. So if you are ever having to look at that issue, Re Owies is an authority for this, whether it is a fiduciary or not. So the fact that guardian had not expressly consented, like I would, if I was drafting a document, I would make sure that there was a section in the deed of variation that said, Eva as guardian consents. I'd have her in there as her own party in the role of guardian, as well as signing as a director or secretary of the corporate trustee. I might even have a separate one-pager consent as well, so there's no ambiguity. But here they said, okay, we've got enough evidence circumstantially to say that she did consent. As a side, we saw in the Re Nariman super case in 2018, they were not as forgiving as they were in Re Owies, where I always wonder if his name is Gillies or Giles. So John, I'll just call him John. So he signed as the trustee, sole director and secretary, but the document said he was signing as an authorized representative, not in his capacity as director and secretary. And so that document failed and it wasn't effective. So you do have to be really careful about just getting everyone in their roles documented properly. Another case, I won't actually go through this one because we're right at the top of the hour, but it's another one worth reading from Western Australia. Again, another sort of who's the appointer, who's the principal decision. And they had a very similar variation power that had to be interpreted about whether it was trusts or mere powers. So that's another one to read through if you really want to do a deep dive on that the scope of the variation power. But the main message is that the exact terms of your trustee really do matter. You have to be really on the ball to read through all of them. So I would say whenever you're doing anything with a discretionary trust deed or any deed really, like print it out, read it like from front to back very slowly, read every page. Don't just go cherry pick and go, oh, I'm looking for change of trustee or change of appointer, or so I'll just like read the pages that it's on. It's really risky, and you can't be on autopilot because we don't know what the settlers intended and where they put things all over the place. I will just give a little plug to, if you are looking to do, or you do find yourself changing principals and appointors or needing to put in place a succession plan for those roles, I have a precedent that is white labeled that you can buy on this. So you get deed of succession for the role of appointer, principal, guardian or trustee, a deed of retirement and appointment for appointer, principal, guardian, not for a trustee, because there's a lot of stamp duty issues, so that is a separate thing. You get a deed of variation precedent to update the succession mechanisms for the roles if your current deed doesn't have an effective power to nominate a successor. You get a template letter summarizing the recommendations to send to clients. and sending out the documents for signing. And there's, I think the most important thing is you get really detailed user notes. So basically saying, make sure you've got all of these things. Check the variation power allows you to amend the schedule if you're going to do it, and difference between trust powers and all of that. And there's a really detailed training that goes along with it as well. So it's really designed, it's just for lawyers, but it's really designed to make sure you don't get caught up in making these mistakes and having your client be the test case. So I think we're pretty much on the top of the hour now. So I'm just checking. I can't see any more questions. I just want to say thank you to everybody who has submitted a question. Really good discussion points. If you do have any more questions, or you're watching this on the replay, send through your questions in the chat, and I'm happy to answer them afterwards. I'm going to put the link to the part 1 and also that family trust succession precedent there for you if you are interested in any of that. And thank you everyone who made time to join me live. I'll see you all next month. Take care.